Prime Minister Mark Carney's decision to appeal the Emergencies Act rulings puts the Supreme Court in an untenable position. Chief Justice Richard Wagner's past public comments on the Freedom Convoy raised doubts about whether he can judge the case fairly. The government announced its appeal to the Supreme Court on March 17th, the final day permitted under law. The government chose to defend what two courts found were constitutional violations, rather than admit that the Trudeau government violated Canadians' charter rights. The Federal Court of Appeal was clear. The government lacked reasonable grounds to believe a national security threat existed. The legal threshold to invoke the act had not been met. Freezing bank accounts without prior judicial authorization breached the charter, which protects Canadians from unreasonable government action. The Chief Justice publicly condemned the Freedom Convoy protests in April 2022, calling them the beginning of anarchy, where some people have decided to take other citizens hostage, to take the law into their own hands. These comments now raise a constitutional problem if the case reaches the Supreme Court. He told Le Devoir that such protests must be denounced with force by all the figures of power in the country. He characterized protesters as remotely guided people with a certain ignorance of the rule of law. 13 lawyers filed a complaint alleging apprehension of bias, meaning a reasonable person could question Wagner's impartiality. However, the Canadian Judicial Council dismissed the complaint as unsupported and without substance. Now, a case the Chief Justice has already publicly commented on may land before him. He faces an impossible choice: recuse himself and acknowledge his comments created bias, undermining confidence in the Supreme Court, or sit on the panel and render judgment where his public statements aligned with the government's position against citizens whom lower courts found were exercising charter-protected freedoms. If the Chief Justice recuses, Canada's highest court will hear one of its most important constitutional cases in decades without him. If he sits, Canadians watch their Chief Justice rule, having already described the protesters as people taking other citizens hostage. The Prime Minister's decision reflects the constitutional recklessness that marked his support for freezing bank accounts. In 2022, he endorsed using the financial system as a weapon against protesters. The Federal Court of Appeal ruled that the measures were not justified under the law and breached charter protections. Now, the Prime Minister asked the Supreme Court to reverse that finding, one presided over by a Chief Justice who publicly supported strong action against the protests. The appeal serves no principle beyond saving face. It shifts the focus from the previous rulings to whether the Supreme Court can be seen as impartial in this case. The Prime Minister inherited this mess from Trudeau and chose to own it. Several ministers who were central figures in the Trudeau government still sit around the cabinet table. Their judgment is on trial too. Yet the Prime Minister asks the Supreme Court to declare that freezing citizens' bank accounts without warrants or judicial oversight somehow squares with the Charter. The political calculation is transparent. An appeal keeps the issue alive, delays accountability, and shields his colleagues until after the next election. Canadians who already struggle with institutional trust watch the country's highest court drawn directly into the controversy. The Chief Justice's predicament shows the risk of judges making public commentary. His 2022 comments reflected a broader consensus that the convoy was dangerous and the Emergencies Act was necessary. But consensus is not law. Courts ruled that the government violated charter rights and that the emergency powers were unjustified. That's on the record. The Chief Justice, who must now adjudicate these findings, already publicly declared the protests were anarchic hostage-taking. Whatever the Supreme Court decides, many Canadians will believe the fix was in. If the Chief Justice sits and rules for the government, civil libertarians will point to his 2022 comments. If he sits and rules against the government, both sides will question why he did not recuse. The Prime Minister and Cabinet chose this path. By pursuing this appeal, they have ensured that whatever the Supreme Court decides will be seen by many as compromised.
Please like, share, and subscribe if you appreciate this content.